Good afternoon, everybody. My name is Katie Robert. I am here with the Community Health Institute, JSI, and we're here representing the Healthy Families America New Hampshire Home Visiting Program. We're really excited to have attorney Kerstin Cornell with us here today from New Hampshire Legal Assistance. Many of you may remember that last year we had done a webinar on tenants' rights in New Hampshire. And so given that there are lots of changes happening with the potential expiration of certain COVID accommodations that had been made to housing and eviction laws, we heard staff loud and clear, and we wanted to provide an opportunity to ask Attorney Cornell some questions about how it is that we can support families in navigating this time as it relates to their housing needs. So I'm just going to say from the get-go that Attorney Cornell is here providing legal information, not legal advice, and she will divert as needed, but I just wanted to make sure that everyone is aware that she's here kind of providing information and not serving in any kind of formal legal capacity. So I'd like to go ahead and welcome Kerstin. Thank you so much for being here today. And I know you were going to give us a little intro, a little overview of some of the resources and supports that are available, and then we'll jump in.
Yeah, thanks for having me. I'm happy to be here. Please feel free if you haven't had a chance to enter your questions. I think you can do that on chat, and hopefully we'll get through as many as possible. Like Katie was just saying, I am here to provide legal information, so none of what I'm saying should be taken as advice or used to make a decision about any case that may come up. I know that accessing legal aid can be pretty tricky and that it's kind of circuitous. So I thought that I would start with just talking about the legal aid resources that are available in New Hampshire. There's obviously New Hampshire Legal Assistance, which is where I'm from. But the path to us is not always straightforward. So the Legal Advice and Referral Center is an organization that provides phone advice and can provide assistance writing pleadings for folks who have to go to court on their own. And they also serve as the intake point for both NHLA as well as an organization called Pro Bono. Pro Bono is an organization that matches eligible clients with a private attorney who will take their case on for no fee. And there are income restrictions associated with both of our programs. So NHLA provides assistance to folks who make 200% of the federal poverty guidelines or below. And Pro Bono assists at 187.5% of the federal poverty guidelines below. And I'm not going to do the math for you on that, but I'm sure you can do that. In terms of other free assistance, there's something called Free Legal Answers, which is relatively new. You can Google Free Legal Answers in New Hampshire and it will pop up. There's income guidelines on that as well. I don't know them as specifically, but basically what happens is if you have a particular question, you can type it in and then attorneys sign up to use the service or to help with the service, and they'll answer the question as they have time to. So sometimes you get a quick answer, sometimes it takes a while, but that is something that's also available. We at NHLA are also going to be starting eviction clinics soon. And so what that means is that starting next week, we'll be doing hour-and-a-half-long clinics about eviction defense. We are planning to do one in the afternoon to try to accommodate folks who work for social service agencies. And then one in the evening to try to accommodate folks who work during the day. So the afternoon we're planning to do every other week, and then the evening clinic will be every week, and it will be different advocates from NHLA providing basic information about how to defend against an eviction. If you don't qualify for any of the free legal assistance, there are some other programs that can help you. So there's a modest means program, which tries to fill the gap between folks who qualify for free legal aid and folks who can afford to pay an attorney at full fee. And so what it does is it will ask the person who calls in some questions about their income, and then based on that, they qualify for a reduced rate. So attorneys will sign up to who are willing to accept cases at $80 an hour, $100 an hour, $125, depending on the income level of the applicant. So that's something that's available to middle income folks who maybe need some help but can't afford to pay an attorney who charges their regular fee. That's basically where things are at in New Hampshire. I always advise people that if they don't know where to go, to call the Legal Advice and Referral Center. I know that wait times can be really long. If your clients are able to access the internet, or if you can help them access the internet, there is an application that can be filled out on legalaid.org. And then you will get a call back. They'll set a time for you to get a call back. And that way they can plan a little bit better and don't end up waiting for an hour and a half on the phone, which I know not everybody has. So that's a way to try and plan a little bit better. So I think that's generally the lay of the land for legal aid in New Hampshire right now.
Thanks for that overview, Kerstin. So the purpose of going through that was that we know that as we talk about a lot of these questions, there might be things that come up and pop up in your mind. And while we may not be able to necessarily get to them during the call today, we wanted to make sure that you knew these resources existed and that they were in your mind as you started thinking about those questions. One follow-up that I have, though, is you talked about the new weekly clinics. How do people sign up for those?
There's no sign up required. We'll be pushing out a link through our social media networks as well as to all of our partner agencies. My understanding is that there will be a flyer put at like local welfare, something along those lines. I'm not doing a lot of the planning for that, but if you can find NHLA on social media platforms, there will be a link for you to find, and then you just have to click on that. It's just a Zoom webinar.
Great. We can send a link to that to the Facebook page when we send out the recording link. So that's great. Thank you. So one of the reasons why we brought this together, thanks to a few home visitors and family support specialists who kind of raised this question, was that there's a lot of things changing with the COVID accommodations that have been made to housing and eviction laws. And so I was wondering, Kerstin, if you would mind giving us a little bit of a snapshot of what it is that you see on the horizon, what is changing, what might not be changing. I know there's a lot that we don't know, but
Yeah.
if you could share what you can, that'd be great.
Yeah, for sure. So I will talk a little bit about the few things that are standing currently. I think folks are mostly aware of the CDC moratorium on eviction. It was issued by the Centers for Disease Control and basically prevents people from being evicted if they can sign a declaratory statement that they've lost income, that they will not make over $99,000 a year, that they are likely to become homeless in the instance that they are evicted. And if you're able to sign, there's a couple of other that I can't remember off the top of my head. If you're able to sign that statement and provide it to your landlord, then you're protected from eviction, at least for non-payment. There is an argument to be made, and we have been successful in some courts, that this moratorium applies not just to non-payment evictions, but also to evictions that are not for cause. So if an eviction is for something along the lines of the landlord wants to remediate the home or wants to take it off the market or wants to move in, something along those lines, we have had some success arguing that this eviction applies, that this moratorium applies to those evictions as well. And the reason for that is that the policy statement that's set out in the moratorium is basically to say that we don't want people to be homeless because it will increase the spread of COVID. And so that's the only moratorium that currently stands. It is in effect until the end of this month. It was originally set to expire at the end of last month, but it was extended. We have no idea what will happen at the end of this month. I really wish that I could tell you more than that. In terms of a moratorium, what we do know is that we're going to be getting more federal money coming into the state to assist with housing payment assistance. We don't know how much exactly. We don't know exactly how that will be distributed. everything's up in the air. The money that came in previously through the CARES Act was distributed through the CAP agencies. So I think that there's some likelihood that that will be the process again, but we don't have any specific information that indicates that's true. For now, that's about it for COVID protections. The one other thing that's becoming less relevant is that for a non-payment eviction, if it includes a demand for rent that occurred or became due between March 17th and June 11th, then a 30-day notice is required rather than the 7-day notice, which is typically required for a non-payment eviction. As we're getting farther away from that time frame, that's becoming less relevant, but it is still something that's hanging on. I can't hear you.
I'm muted there. Classic. So if there was a piece of advice that you had for home visitors and family support specialists to potentially anticipate, or conversations that they might have with families who are potentially facing some housing issues in the next few weeks, do you have any kind of top level tips that you might have them thinking about before some of those changes happen?
So, I mean, it depends. The first thing I always tell people is if you're facing eviction, regardless of whether you think that the grounds are legitimate, it's always good to start looking for a place to go because nothing is guaranteed. I know that the housing market right now in New Hampshire is incredibly difficult. We always encourage people to keep a log of everywhere that they look so that in the instance that they need to ask for more time in their home, they're able to show that they have been making efforts to find a place to go. If it's an issue of money, and there's an amount of money that will protect somebody's housing, we encourage them to go to local welfare. A lot of times they're able to provide financial assistance to stabilize housing. Something that I'm not sure everybody knows is that something that NHLA does is we provide support for applicants who are denied assistance through local welfare. Every day we have an advocate who's essentially on call. And so if an individual goes and seeks assistance through local welfare and they're denied, they can call our number directly, and the phone tree number I think is 4. And we will do our best to provide emergency assistance to see if we can help them navigate perhaps what went wrong, what's needed in order to get the assistance. So I always direct people to that resource as well if it's a financial situation. Mm-hmm. Does that answer your question?
Yeah. And I just want to remind folks, you can also be chatting in questions into the chat box. We will do our best to answer them as we can. We do want to make sure that we address all of the questions that were submitted ahead of time. So we will kind of fit in as much as possible. And Attorney Cornell had offered an additional few minutes towards the end of the call if we need to run over a little bit, if that's still a possibility. So why don't we go ahead and pivot to some general eviction processes? I know a few of the questions that we had gotten that we'd received prior to the session were just kind of, can you give an overview of what a regular eviction process looks like? And so I know it's a really complicated, specific process depending on the situation, but if you could give some of the high level points, I think that'd be great.
Yeah, so I think the best way to do this is probably at 2 levels. So at a really high level, the process is this. You get an eviction notice. After the eviction notice expires, the landlord goes to court and they get what's called a landlord tenant writ, which has to be served by a sheriff. On the writ, there's a return day. By the return day, you have to file an appearance at the court. That's how you ask for a court hearing. You have a hearing, and then in the instance that you do not prevail, you have 7 days to appeal. And the 8th day, if there is no appeal on the 8th day, a writ of possession issues, and a sheriff executes the writ of possession, and it's at that time that a family can be obligated to leave their home. So something that I try to impress upon everybody I talk to is that your landlord can't just kick you out. They can't come to your house and say, you have to leave right now and change the locks. A judge has to go through the eviction process. A judge has to sign a writ of possession, and the sheriff has to bring it before you can be required to leave. So that's really important to know. What the eviction notice is more or less is a warning. So nothing actually happens with a court process until the eviction notice expires and the family stays in the home. Once that happens and they go get the landlord tenant writ, that is when technically the legal process begins. The eviction notice, however, is a little bit complicated because there are a couple of timelines based on the reason for eviction. So for most evictions, it requires a 30-day notice. And that means that the time from when the eviction notice is served to when the family has to vacate would be 30 days. However, in instances of non-payment or if the reason is for a threat to health and safety, then those only require a 7-day notice. And so they move much more quickly. So what's really important is that you make sure that family makes sure that they're looking at the dates on the notice, that they realize they don't have to be out the date that the notice expires. But once that date does expire, they need to start watching for the writ to come. Once the eviction notice has expired, if they haven't received a writ within like a week, we encourage them to call the sheriff and see if there's anything that needs to be served. And then once the writ comes, there's usually about a 10-day period, 7 to 10-day period between when the writ will be served and what's called the return day. And so, as I said, the return day is when you have to file an appearance with the court. If you don't have a lawyer, then you need to go and do that yourself. If you do have a lawyer, then the lawyer will do that. It's a very simple form. You just go to the clerk's desk, ask for an appearance, check a couple boxes and sign something. And then that's how you ask for a hearing. So a hearing will be set usually 7 to 10 days after the appearance is filed. That's not really true right now. Everything is kind of extended because of COVID. Nearly all of the hearings are being held telephonically. There are a few courts that are having in-person hearings, but they're not many. Once the hearing date is set, that's when you appear. You have the opportunity to present your case, and the judge will make a decision. And then, like I said, there's a period of time that elapses before the writ of possession issues. There are a few things that can be done in the middle there. And this is why I encourage people to contact LARC if they have an eviction that's more complicated than non-payment, that they understand that they owe the correct amount of money and can try and use some social service agencies to access that money in order to overcome the eviction. Something I should have mentioned is that for a non-payment eviction, if you the family pays the full amount on the demand for rent plus $15 of what's called liquidated damages, then that cures the eviction. It makes it go away. And so that's when local welfare or CAP agencies can be really helpful. Unfortunately, you can only use that process 3 times in a 12-month period. So it's not something to rely on, but it is sometimes a good save if that's what you need. And again, that's why I encourage people to go to local welfare.
Great. Well, we're doing okay on time. So if it's all right, I'm gonna read out one of the questions that just came in from Creanne. Creanne is a friend who is a nurse with 2 children in her condo, and she rents. And the owner of the condo recently decided to sell due to the high market values. She hasn't been evicted technically, but forewarned. She has a realtor that she's working with, and she's really struggling coming up with finding any 3-bedroom units at this time. What rights does she have, and can she be evicted if she can't find a new home by the time the owner sells?
Right. So I'm going to answer this question really generally and not fact specific because we're getting wading into case specific. But what I will say is that that would be an example of a non-fault eviction, which we've had some success defeating with the CDC moratorium. It's not clear whether the moratorium applies to that. And so it's like I said, we've had some success. I believe that it falls within the parameters of what the moratorium is meant to protect, but ultimately that decision is made by the judge. So I would encourage her to check out, to invoke the CDC moratorium, you have to complete the declaration, which is available online, and then give it to your landlord. If the landlord is represented, then you need to give a copy to the landlord and to their attorney. Something else that I should have mentioned in my description of the eviction process is that if you do in fact lose at the hearing and you haven't found a place to go, you can ask the judge for what's called a discretionary stay. And a discretionary stay basically puts the case on hold and gives some additional time to find a spot. And it's called a discretionary stay because it's entirely at the judge's discretion. It's up to 90 days, but they can say any amount between 0 and 90. And this is when it's really important to have kept a log of where you've been looking to find a place to go, because there's a lot, it's a much better argument to a judge to say, look, I've made these 50 calls to places and I can't find anything, or I've spent this number of hours looking on Facebook or Craigslist or wherever to find an apartment and I just haven't been able to, than to have nothing to show and to just make that statement. So we always encourage that. So there's the possibility of the discretionary stay if the CDC moratorium doesn't overcome that type of eviction. But unfortunately, it's just a really terrible housing market right now, and everybody is struggling.
Thanks, Kerstin. Another question that's come in. So if a tenant doesn't have a lease and they've paid all their rent, can they still be evicted? Thinking of a situation where the landlord was upset about the tenant calling the health inspector to get things fixed.
Yeah, so a lease is not necessary in order to create a landlord-tenant relationship. And what you're looking at is, what you're trying to find is the landlord-tenant relationship. So a landlord-tenant relationship is formed when two parties agree that one will live in a property owned by the other and consistently pays some sum of money in order to live there. And what that does is it creates a month-to-month tenancy. Anytime you have a landlord-tenant relationship, you have the right to the lawful eviction process, which is what I just described. And so in order for your landlord to evict you, they have to go through that whole process of giving notice, going to court, etc. So it's not as simple as just kicking someone out because they don't have a lease. What we're really looking at is the relationship between the two parties.
Mm-hmm. Okay. All right. So why don't we go ahead and move into kind of the formal Q&A process. And so we really appreciated everyone sending in their questions ahead of time. Attorney Cornell and I spent some time last week going through and kind of organizing the questions in what will hopefully seem like a natural flow. But again, please feel free to chat in as we go. We're going to kind of bucket our questions by more specific to the general eviction process, questions around landlord responsibilities, and then also some lease questions. So hopefully everyone who has submitted questions, you'll see your questions in here. So is it all right if I just go ahead and start peppering you? All right.
Yeah, let's go.
So first question is, as home visiting staff, what is the first thing we should tell a family when their landlord calls or texts them and says they are being evicted in 8 days?
So the 8 days on this gives me a little bit of pause. So again, I'm going to answer this in 2 days, 2 ways. The first is to say that you have the right to the lawful eviction process. So your landlord can't just come and lock you out. They like to scare people, but they can't. The reason that the 8 days gives me pause is because that's the amount of time that elapses between the time that a judgment is rendered and a writ of possession is issued. And what can happen sometimes is if a person who's facing eviction doesn't file an appearance, then they can end up with a default judgment entering against them, which just basically is judgment for the landlord. They become evicted. And so the writ of possession would issue. And so that's why I give pause. If somebody tells you a specific number of days, I would ask them if they have received any paperwork, they've received an eviction notice, a landlord-tenant writ. Just try and see if there's anything that they've gotten, that they've set aside, that, would have indicated that this process has been ongoing for some time. If there is nothing and the landlord is really insistent that something is filed, what you can do is you can call the court call center, which is just a general phone center that's 1-855-212-1234. Somebody can type that somewhere. And you can ask the person who you want to dial for district court, which is choice 1. And you can just ask if there's a matter pending with your name and address. And if there is, then that'll give you that information. Usually what that means when a landlord calls and threatens is that they're planning to give you an eviction notice and they're trying to scare you into leaving in the first place. So in that instance, I would talk to the family about the things that we just discussed, the fact that they have a right to the lawful eviction process, that they have a right to a hearing before a judge, that there is quite a long period of time before they will actually have to leave, even from the time that the landlord gives an eviction notice. And simply sending a text or making a call and saying, I'm evicting you, doesn't meet the requirements of an eviction notice under the law. So that's just a starting point. I'd make sure that things are tracked down. If it's an instance where a family is behind on rent, again, I would encourage them to reach out to local welfare, social service agencies to try to see if they can get some assistance to become current before it goes on to the eviction process.
Kirsten, would you mind repeting that phone number one more time?
I know,
Sounds
I
like
said
you
it
got
really
right off the
fast.
top of your head so that we can.
It's 1-855-212-1234. You're gonna be on hold for a long time. Call early in the morning. They're really overwhelmed because of COVID.
I just put that number into the chat. And again, that's a piece of information we can include in the follow-up email that we send out to everybody. So, all right, Nick.
Oh, I'm sorry to interrupt. This is Krian. That number that was just provided is for the name and address check, correct? To see if there's anything pending?
Yeah, so it goes to the court call center and you can just explain the situation and ask if there are any matters pending with your name.
Thank you.
Yeah.
Thanks for that clarification, asking that clarification, Krian. All right, so moving on to the next question. The landlord has a sheriff serve papers and the sheriff tapes them to the door and the address on the papers is correct, but the names on the paper are next door neighbors. Does this still count as an eviction notice?
It's a really good question and not one that I'm going to answer very well. What I will say is that the law requires that the eviction notice be sufficient to give the person who is being evicted a clear understanding of the reason that they're being evicted. If a person is able to understand that the eviction notice is for them, not for their neighbors, it's possible that there could be an argument that it did meet those requirements. That said, there are a lot of technical defenses to be made against evictions. I think that, that kind of thing is something that I would encourage people to call the Legal Advice and Referral Center about, because there's always more to a story. It's never that straightforward. So I will just say that, there are specificity requirements for an eviction notice. And that if eviction notices are not specific enough, and if they do not include the correct information, then they can oftentimes be overcome on technical grounds. That specific instance, I would want more information on before I would give a more specific opinion.
Okay, thanks. All right, so our third question in this section, what are the stages of eviction? From verbal warning from the landlord to court appearances, how long does this take and who schedules the court hearings? Is it the family or the landlord?
Yeah, so it's basically what I just went through. So I'll give you some time. I gave you some time frames. Like I said, so there's a 7-day notice on the eviction if it's for non-payment or threat to health and safety. Otherwise, it's a 30 days. And that's just a warning. That's just like the very beginning saying like, hey, I'm going to take you to court and kick you out. And then they have to go and get the landlord tenant writ. And like I said, there's about 10 days between that and the return day. In normal times, there's usually 7 to 10 days between the return day and the hearing. Right now, it really depends on the courts. In the larger cities, I'm seeing 3 weeks between a return day and a hearing, but everything is so up in the air that that's certainly not something to count on. We always encourage folks to file their appearance the day before the return day because it will allow them, some time in the apartment to continue looking for a place, but we'll make sure they don't miss that return day. So, and then, like I said, depending on whether, if judgment is granted for your landlord, then there's 8 days until the writ of possession is generated, and then it has to be executed by a sheriff. And there's usually a couple of days that pass between when the writ of possession is issued and when it's actually served. Something that I should have mentioned is that your landlord is required, though people have to leave the apartment on the day that the writ of possession is executed, your landlord is obligated to protect the possessions that are in the unit for 7 days. And so what that means is that they can lock you out, but they have to let you in to get your stuff. And they can't just throw it out. They can't make you bring everything with you in the couple of hours that the sheriff gives you to get out. However, after those 7 days have elapsed, the landlord can do with your things whatever they want. So definitely make sure that you have a plan to either put them in storage, find a friend, sell them, do something.
Okay. Another one, which is I think going to be kind of tied back to the COVID questions. Are evictions still legal for reasons other than non-payment, or are all evictions being held?
Yeah, so, and again, it's, we don't know. Non-payment evictions are protected under the CDC moratorium, like I said. Whether for cause evictions are not protected. So I will say if you have a lease violation, a threat to health and safety, something along those lines, and that's not protected. If it's a matter of your landlord wanting to, like I said, renovate the apartment, sell it, something, there is an argument to be made that that's protected, but it isn't clear. The language isn't clear. We've had some success, but so in those instances, again, I encourage you to call the Legal Advice and Referral Center. They can pass you on to NHLA if it's the kind of case that we accept. If it's not, then they can help you get ready to represent yourself. So that either by helping you draft a pleading to give the court, or just sort of helping you understand what you need to tell the judge on the day of the hearing. Hopefully something more will happen. Yes. Who knows what's to come? I hope something better does.
Yeah. All right, so we're gonna transition into some questions that we received around landlord responsibilities, but I'll just remind folks again, feel free to chat in questions and we'll take them as we can. So, all right, first question here. I'd like to know what responsibilities fall on the landlord, and if someone can be evicted for failing to pay rent because the landlord hasn't fixed major repairs, such as broken windows and toilets not working.
Yeah, so the landlord is responsible for maintaining what are termed minimum standards to create a habitable living environment. And what those minimum standards are depends on where you live. So there are statewide minimum standards that have to be met, but municipalities can set their own as well. And so that would be in the housing code, and that would be enforced by code enforcement. The minimum standards apply to things like pests and plumbing, exposed electrical outlets, leaks, water leaks, falling plaster, structural instability, that kind of thing. Heat is a big one. Your landlord has to either, if they pay for the heat, they have to maintain the heat at 65 degrees or higher in all habitable rooms. Or they have to, if you pay for the heat, they have to provide sufficient heating system that allows that temperature to be achieved. Mm-hmm. If those standards are not met, you should call the code enforcement officer for the municipality, and they'll come out and do an inspection, and they can require that your landlord make they fix the problems. But it does get tricky because obviously landlords can sometimes become frustrated with this. And so the question about rent becomes a matter of rent withholding, which is one approach that tenants can take to try to get their landlord to provide them with what they're entitled to. But doing rent withholding is a little bit complicated. And if it's not done properly, it's not going to work as a defense in court. And that's really where rent withholding carries weight. So I guess two ways. One, if you withhold rent, maybe your landlord will act. That'd be great. But the other possibility is that instead they evict you for non-payment. If you have told your landlord that you will not be paying rent in writing before you are in arrears, so you have to be current on your rent. You have to give your landlord 14 days notice that there is some sort of problem that needs to be fixed. And you have to give that notice in writing. And then you can withhold your rent lawfully until those items are fixed. But the trick is that if you're going to use this as a defense in court, you have to have the money to be able to pay. And so lawful rent withholding requires not in arrears when you make the decision, when you give the notice to withhold, that you have the money, which is really difficult because there are so many things that people need to pay, that holding on to money that you feel you shouldn't have to pay for, poor conditions, understandable. But in order to use it as a defense, you will need to have it. And then, the 14 days prior. And in that case, yeah, you can use it as a defense. So you can go to court and you can say, I'm behind on rent because, there are all these problems with my apartment. I look at this text message or this email or this letter that I gave to my landlord, letting them know that I'm going to rent withhold and here's the money. So that is the way that you can rent withhold. I always encourage people to try code enforcement first and see if they can get some traction there. In some instances, if you have taken this, if you've given your landlord notice and they have failed to act for things such as interruption of utility services, entering the property without proper notice, trying to circumvent the eviction process, you can file what's called a 540A petition with the district court. And this is one of the things that you are actually allowed to go into court to do right now. It's one of the few things you can go into court. And it's a court form, and the desk clerk can help you with this too. And it's basically check boxes, and you write down the information about what your landlord is not doing that they need to do. And the court can issue an order right there on the spot, ordering your landlord to fix the conditions. So something to keep in mind though, is that in order for 540A to be violated, your landlord has to be doing things willfully. And so again, they have to have had notice and they have to have had time to address the problems that need to be remedied that are the cause of you petitioning for this relief. In certain circumstances, petitions under 540A will result in statutory damages, which means that a certain amount of damages will be awarded regardless of what harm it does, regardless of how much money it costs you. And in other circumstances, you'll entitled to an award of actual damages, which basically means whatever you can show it cost you that these conditions existed. When filling out a 540A petition, we always encourage people just to, and it asks a question about what damages you're seeking, to just put maximum allowed under law.
Kerstin, is the 540A petition something that people can get online before going into court?
Yeah, it is.
Time?
Yep. So the New Hampshire Judicial Branch Court website has the court forms on it, and a 540A is one of the ones that you can get.
Great. Thank you. All right. So the next two questions kind of piggyback on payment related questions. Is it allowed for the landlord to say that they can only accept full payment?
Yes, they can. But the truth is that you want them to say that. And the reason is this: you can pay your landlord any amount of money. And unless you have paid rent in full, they can still evict you for non-payment, unless you have a written agreement between you and your landlord saying that you'll pay $300 on the first week and $300 the second week, so forth. So if you have that in writing, then, you know, the full amount that would be owed would be the amount in that writing. But absent some sort of writing, if you give your landlord $500 and your rent's $1,000, they can still evict you for the $500. And then you're out the other $500 that you had already paid. And so it's actually advisable to pay your landlord in full. Again, if you have some of the money, but not all of the money, this is another time when you can go to local welfare, and they can assist you with the rest to try and help you out. If you go to local welfare and they say that they aren't able to assist you because you don't have an eviction notice or something along those lines, that would be a time to call us, and we can try and investigate the situation and see whether you are entitled to assistance. But the short answer is that yes, but that is the better path forward ultimately. I would encourage you though to keep the money you have, because if you do get assistance from local welfare, they're going to require that you use all of your resources before they will assist. So if you had the 500 towards the 1,000, you're going to need that 500 before they'll give you the next 500.
And what about a landlord giving an eviction notice when you've only missed 1 month? Is that allowed?
Yes, they can evict you for any amount of non-payment. So typically a lease will have some sort of provision that rent is due by a certain date. Like rent is always due by the 1st, almost always, but usually there's some sort of grace period giving people until the 5th or something along those lines. And then, you know, maybe during that time, a late fee will be charged. Maybe it won't be charged until after that time. But once you've passed that time, they can evict you for any amount of money owed for non-payment. They don't have to wait for a long time. You're muted.
Moving into our last section of questions. Someday I will have a Zoom meeting where I am muted and unmuted at all the right times.
That would be boring.
Not today though. So moving into our last section of questions, kind of talking about some lease considerations. So again, please feel free to chat in questions as you have them. The first question we have here is there any law that can support not evicting a client when a spouse or other person on a lease dies?
So the question is whether the person who is still alive is on the lease, because the lease would hold if that person is on the lease. However, that person is going to be responsible for the full amount of rent. A lease makes one both jointly and severally liable. So that means that, you know, any one person has to make sure that all of the rent is paid, regardless of the agreement between the people who live in the house. So if one person is on the lease, if both of them are on the lease and their partner or spouse dies, then they should be able to continue the tenancy so long as they can continue to pay the rent. If they are not on the lease, however, then they don't have, well, I would say to call us. They may have the right to continue living there. There would be some fact determinations, but not on the lease makes it unlikely.
Okay. And how do you go about removing a partner from a lease or a housing voucher?
So that's a couple of separate things. A housing voucher is more complicated than I'm going to get into right now. There are a lot of different considerations. It can differ by housing authorities. So if that's a situation you're facing, again, I hate to be a broken record, but I would encourage you to call LARC for some help, because that can be a complicated process. In terms of a lease, a lease is in place for the duration of time that it exists. So usually it's 1 year, and then the default in New Hampshire is that it goes month to month. For 1 year, for the duration of the lease, so let's say it's a 1-year lease. If you want to get somebody off the lease, you can negotiate with the landlord to change the lease. The person could tell the landlord they no longer want to be on the lease. Again, the other person on the lease would be required to pay the full amount of rent. But that's really a question of contract. Once it goes month to month, the decision is made on 30-day basis. So it's essentially each 30 days is essentially a renewal of the lease. And so again, it's basically just a conversation to have with your landlord, and some sort of agreement to come to with whoever you're living with. The Section 8 voucher makes it a lot more complicated. So.
And I suppose it becomes more complicated if the landlord isn't willing to change the lease or make that accommodation.
Right.
What would be the next step and at that point?
So I would try again to reach out to us. Sometimes we can negotiate agreements. I always just try and tell people to be human. If they will not let you change the lease and you're outside of the 1-year lease period, then you can give 30 days notice and move to a different location. So if you really don't want to be with that person, you may end up having to be the person to leave. There are some protections under the Violence Against Women Act that pertain to circumstances in which a partner is abusive. Those are also more complicated than I'm going to get into in this forum. But if it is a circumstance in which there is domestic violence involved, there may be some other ways around it. And some other, I shouldn't say ways around it, some further protections that are offered by the law. And in that instance, I would encourage folks to contact their local crisis center. NHLA works with crisis centers throughout the state to navigate legal issues like that. But in those circumstances, there's frequently other considerations that need to be made before making decisions. So I would encourage them to access that agency.
Great, thank you. All right, and then the last, actually, I'm going to take this quick question from Paula because it is, I think it's directly tied to this previous question. What if you just want a person to leave and they won't if they are on the lease? Example, like if a couple broke up.
They're on the lease.
Yeah, so everything.
Like I said, it's at that point, like it's a negotiation between the people on the lease and the landlord. So I would be surprised if there was a circumstance where a person wanted to move out and the other person was willing to assume the rent, despite the other person moving out. I would be surprised if a landlord said no. If it's a matter of not being able to afford rent, then it's going to get trickier. And if it's a matter of somebody not leaving absent some sort of, like I said, abusive situation, there's not a lot the law's going to do for you.
All right. So we're coming up on our last question that was submitted. If a client qualified for a place prior to COVID based on income, but post-COVID has a different or no income, will they be asked to vacate since they no longer qualify? What's the process if they have to leave and how much time do they have?
So I'm not really sure what this question means. And if the person who asks it wants to type into chat, that's cool. I'm not sure exactly what qualified for a place prior to COVID means. If it's an issue of loss of income and needing to have the portion of rent changed because you have some sort of subsidy, then that person would need to do an interim recertification process, which would require that they provide whatever housing authority is responsible for the voucher, proof that their income has changed, and then their rent should be recalculated based on that. So if that's the issue, that would be that process. If a person is living in a place and their income changes and they simply are no longer able to afford the rent, then they're still entitled to the lawful eviction process and, you know, can access the social services that I've mentioned throughout. If they're on a wait list of some kind, and they will have to, again, prove, I'm like just trying to come up with scenarios here. They'll have to prove that they qualify by income, and they can't, and they haven't come up on the wait list, then I don't know that there is a legal defense for that. But they certainly can't just be kicked out because their income changed. They have, you know, once you're a tenant, you have the right to the eviction process. You have all of the rights that we've just discussed. And so I would just say, don't be intimidated by your landlord.
Great. Well, that brings us to the end of our pre-submitted questions. I'm going to go ahead and just open it up. If people want to unmute, ask a question, chat a question in, please feel free. All right. Well, seeing as that we don't have any questions coming in, I'm going to ask my colleague Alyssa to launch a quick poll. We're not going to send out an evaluation to the link, but if you could all just take a quick moment to fill out this poll just to let us know how the session was. This is the first time we've done this kind of live chat, and we're excited for the potential in offering similar things in the morning, or in the morning. Oh, I'm in double duty brain in the future, in the spring. And
I think I just saw a question came up.
Yeah, we got one. We have another question in here. Can people be evicted who are couch surfing and have been there for months?
So I'm really glad you asked this question. Usually leases have some kind of provision about the number of days that the person on the lease or people on the lease can have a guest. And usually that is a couple of weeks per year. So what could happen is that if a person is staying with another person who leases rather than owns the place that they're living, the person on the lease could face eviction for having them stay there for a longer period of time than they're allowed to have guests. So that's something to definitely be careful about because you don't want your friends to get evicted because you're staying on their couch. If you are staying with somebody and they want you to go, there's a whole separate process. Like if you're in like a shared living situation, there's a whole separate process to go through in order to be required to leave. But my concern more would be the getting people evicted.
And one more follow-up question here from Kendra. What's the name of the agency to contact if local welfare can't help with rent?
Well, I'm not sure exactly what that means. If local welfare denies a person assistance and they believe they are wrongfully denied, then they should contact NHLA by calling us directly and pressing number 4, and then they'll get connected with somebody who will then connect them with whoever's on call that day. The community action program can sometimes provide assistance. What I would say is to make sure, try local welfare first. If local welfare says no, make sure you get a notice of decision, a written notice of decision, so that they have told you why, because that will also contain appeal rights. You need to make sure you get it in writing. And sometimes they will give, some suggestions of other places to go that may provide assistance. I do not have a list off the top of my head, but that's the process I would suggest.
there was another comment that Brianna had made that local welfare might refer that person to an agency that can help, along with giving the person a notice of decision from welfare. So.
And I just wanted to follow up with the question I asked about for my family. You said to recommended that they could file a CDC declaration. What is that technically?
So it is a form that you can find online. And it's just basically an explanation. It provides an explanation of the moratorium and then a statement. There are a number of statements that you have to be able to swear to under oath. And so you just sign it and give it to your landlord.
I am going to chat that form link into the chat. I just did a quick Google search.
And would she do this if she's not clear if the moratorium it applies for her in her situation with the condo and the owner selling?
I would encourage her to call the Legal Advice and Referral Center because this is getting too close to a specific question.
Okay.
Sorry.
Thank you.
Yeah.
All right. Well, I do want to say a big thank you to Karen Jameson, who was really kind of the inspiration for this, and I very much appreciated. The team appreciated the suggestion and the ask, and we were excited to be able to offer this. So we're going to go ahead and have Alyssa launch that poll, and we will send out a follow-up email with a few of the resources that were listed today. But we really hope that you're all staying well and healthy. And thank you for all the work that you do to support New Hampshire families. It's a really wonderful community to be a part of, and we're happy to be able to support your work. So
yes, and I want to echo that thank you. The jobs that you do are incredibly difficult, and I can't imagine how daunting they are right now. And they certainly make my job easier. So thank you for the very underappreciated work that you do. I certainly appreciate it a lot.
Great. All right, well, we'll leave the poll open for a few moments. If folks don't mind, we appreciate the feedback. It helps us plan for future offerings and make our work relevant for you. So we hope you all have a wonderful rest of your day. We'll talk to you all soon.
Bye.